warm welcome to all of you, and I can assure you that the food for thought here should probably suffice a little bit of that hunger that you have in a pre-lunch session. It's wonderful for us to have this session where we have eminent panelists from different parts of the world to have sort of a comparative in terms of some of the topics that spread across our geographies. And we thought we could run a few themes in terms of what all we can discuss. And one of the things that is facing us, in India at least, is the issue around banking sector and the irregularities or some of the offenses that are being unearthed in the banking sector. And I thought we could start with receiving some perspectives on this from different parts of the world as to, one, what kind of issues are they facing in this sphere, and what kind of regulations, or what's the update, what kind of actions are they perceiving, what are the different nuances for us to know, like a comparative. Let me throw it open to Rob. Rob, what are you seeing in Australia in terms of the banking sector? Are you seeing some sort of increased incidences on financial irregularities? Are there specific committees, mechanisms to deal with it?
In Australia, thank you, Tushar. In Australia, we've had a banking sector that has made vast amounts of profits, issued dividends to shareholders, and made lots of money for everybody involved in the sector, but not necessarily for the consumer. And for many years, the banking sector was hardly touched by the corporate regulator. Whether it was for money laundering, whether it was for superannuation fund issues, or whether it was for insurance or general financial services. The consumer sector was largely left to one side, and if you were a consumer and you had a problem, you had to fight and sue a large, well-funded bank. We had a Royal Commission last year which opened the lid on the financial services sector, and it was not a pretty sight. The Royal Commission was objected to and resisted by our Conservative government for years. They said it was unnecessary, the banking sector was fine, it was the best in the world, banks made lots of money, people were happy, what's the problem? The lid was lifted and it smelled. It smelled appallingly bad, because what we found was that banks, life insurance companies, superannuation companies, and financial investors were basically on the take, engaging in wholesale, effectively fraud and potentially criminal behaviour, charging for fees for no service, charging people who were dead for services that they no longer obviously needed because they were 6 foot under or they'd been cremated. And they were completely unrepentant about the issue until it came to light during the Royal Commission. Then all the CEOs said, oh, we're terribly sorry. Appallingly bad behaviour. Some people lost their job, including some CEOs. And where was our corporate regulator? Our corporate regulator was nowhere. They were effectively doing quiet deals with banks, enforceable undertakings, we call it, to try and improve their behaviour and move forward in the future. Never once, almost, taking them to court. Never. Now, of course, the Royal Commission has issued its report and was scathing of the regulator, was scathing of banks, was scathing of the executive and management people there. So I think what you're going to find in the next 12, 18 months is a wholesale series of briefs being developed by the regulator to the DPP, the prosecutor, and you're going to find a lot of work for lawyers and criminal defence counsel, for banks and for executives who are likely to face prosecution. A long time overdue. How many there will be, we don't know. But there is likely to be, after our next federal election in May, some wholesale changes to the financial sector to make it far more accountable.
Wow, that's very interesting. Matt, what's your experience? You, in fact, carry 2 geographies that you can speak about. If I can call the place that you lived early part of your life and the place that's your calling at in England. So have you seen, I mean, I know you practice primarily in England, but would you also be able to throw light on what's happening back at New Zealand as well and in this sector, or would you want to sort of limit yourself to speaking?
I will. Can everyone hear me? It's on. The Proceeds of Crime Act came into force in the United Kingdom in 2002, and one of the big and important pieces of that act was the duty on those who are dealing effectively with client money, whether you're an accountant, a bank, a lawyer, to monitor suspicious activity. And where someone in that position receives funds, you're supposed to carry out money laundering checks and ask questions of your client, knowing your client better. The truth is that banks were not particularly good at this compliance and issuing what are called suspicious activity reports. But in the last 5 years, there have been some very high-profile casualties in the United Kingdom. So HSBC came under the spotlight. The investigation's been going on for about 5 years, so it's a well-known, it's not a secret. And at the end of last year, they agreed to pay in the US and the UK 1.9 billion pounds worth of fines.
Wow.
I mean, that's huge. And so what has happened with the banking sector, knowing that these fines are coming, Standard Chartered have also had swinging fines. They have actually started to tidy their act up. And actually now there really are some pretty onerous compliance. The lawyers in compliance have got quite a lot of power in the banking sector. So those fines and those draconian penalties have actually focused attention on the issue, and banks are worried about these fines and are starting to tidy their act up. We can talk about other professions, how they're behaving later. As for New Zealand, I'm a little bit out of the loop there. There have been some quite high-profile, following the collapse of the 2008 collapse, prosecutions. But what I would say is New Zealand is a little bit of an old boy network. And a lot of people who are partners in the law firms, directors in the banks, working for the big accounting firms, they all went to school together.
Wow.
And so it can get a little bit embarrassing. I mean, there was a case called South Canterbury Finance where a lovely gentleman who was friends of everyone from school, turns out had been very naughty with finance, and there was a lot of money laundering and fraud going on.
Wow.
And that divided the community. So you had people literally becoming very critical of those that were bringing the prosecution. I had a personal friend who was very high up in terms of the Financial Conduct Authority in New Zealand. He was criticised publicly, and you had falling outs between the establishment. So New Zealand we're not perfect down there by any means.
Sure. Usaro, what's your experience in terms of the banking sector, and how are the regulators? Are you seeing either an increase, or historically has it been the consistent amount of irregularities? Are they being reported? Are they being investigated? How are the regulators dealing with it?
Thank you very much. Every time I'm called to speak on an issue of corruption from Nigeria, I always start by telling everyone that not everybody in Nigeria is corrupt. And secondly, not every transaction consummated by Nigerians or in Nigeria is a corrupt transaction. I start like that because there's always a misconception. You have to also realize that the banking sector in Nigeria is dependent on the international banking industry. In other words, most of the banks are funded not just by depositors' funds, but by credit from international bankers. So everything that happens internationally has a correlation with what happens in Nigeria. After the banking collapse, the share collapse in 2008, what you then had were prosecutions relying on the common law. But these were complex prosecutions, and I think it's 10 years now, I don't think anyone has been successfully prosecuted. So you then had regulations introduced, but those regulations are obviously not retrospective. So we're looking forward. Going forward, there's been some active steps taken, not only for sanctions, not only with sanctions and punishments, but I think there are private initiatives to start encouraging smaller institutions, financial institutions, to behave in a particular way. One of the initiatives that's been taken recently has been by the Convention on Business Integrity, where for you to access finance in the stock market, you are required to satisfy certain criteria, which is verifiable by the Convention on Business Integrity. We're seeing that to be very effective, and I think very soon South Africa is going to be doing something similar.
So it's interesting. It's actually the eligibility to receive funding, which is actually being used as the driver of the behavior. Matthew, you made a very interesting point in terms of intermediaries like lawyers being subjected to some amount of checks and balances in identifying and reporting suspicious transactions. That brings me to an interesting issue of legal privilege. How would, in your jurisdiction, I mean in England, UK, how would legal privilege interplay with confidentiality, and how does one draw the line as us lawyers in terms of a positive obligation versus maintaining the client privilege or confidentiality?
So there's a difference between confidence and privilege. If I can use, we've had quite a few discussions about arbitration. Arbitration proceedings are regularly confidential, private. But when there is a public interest which intervenes, i.e. the prevention of serious crime, then the public interest normally overrules confidence. So just because something is confidential, such as a doctor-patient relationship or a priest-confession relationship, that's a confidential relationship. That doesn't mean that the state cannot, when it's investigating serious crime, say we need to have that information and you need to give it to us, and they can compel it. So in the UK, it's important to see that distinction. In terms of lawyers and this topic of money laundering, and going back to the suspicious activity report issue, the legal profession has been poor in terms of telling the authorities confidentiality. You're not allowed to tell your client that you are telling the authorities that they've been behaving suspiciously. And at the moment, there is a National Crime Agency investigation with the Solicitor's Regulatory Authority into this issue. That being said, there were 464,000 suspicious activity reports last year, wow. And the state does not have the ability to investigate all of those. So a lot of it's going to come down to bad luck as to whether you didn't report or did report. Privilege is another issue, which I will leave others to go on to, but that's another separate issue about litigation privilege, which is, again, very topical at the moment.
Yeah. Rob, what's your perspective on legal privilege, confidentiality, and how does that interplay with your obligation to report or monitor suspicious transactions?
I think it very much depends upon your domestic law, because all of us as lawyers will be bound by our domestic obligations and our legal obligations in your country, for example, in India, or in Australia, or in the United Kingdom. The International Bar Association and the OECD have a task force which is looking at this very issue of the role and obligation of lawyers in cross-border transactions. We all remember the publicity of Panama and Paradise, when confidential information held by two law firms, Mossack Fonseca and Appleby, in Panama and Paradise in the Caribbean, was taken unlawfully without consent and then disclosed to the investigative consortium of international journalists, and was basically splashed across the media worldwide in terms of what everybody, from the Icelandic Prime Minister to David Cameron's uncle or father-in-law or father, what they were doing with their assets, with their money, with their income, and ultimately whether it was being properly disclosed to local authorities. And so what you are now finding is increased social pressure and attacks by government on the notion of whether in fact lawyers should remain sacrosanct in terms of their ability to have confidential discussions with their client, and or whether legal advice is or is not properly privileged. And that confidence and privilege, as Matthew said, are two different things. And so part of the difficulty for I think, the legal profession is that there is this immense pressure coming from international organisations and from governments wanting tax, wanting revenue, wanting accountability. Politicians like to talk about accountability, but they often don't like accountability themselves. And so they're very quick to say to the legal profession, disclose when you think something is wrong. But that conflicts, like two rocks going together, with the inherent and fundamental issues of confidence and privilege, which are different, in the nature of the client-lawyer relationship. And so the legal profession has tried to strongly resist that disclosure, because as a fundamental rule of law concept, an individual should be free to have independent legal advice and not have that legal advice disclosed simply because somebody else wants to see it. And so you get this tension between what the state, as Matthew said, might want and what the lawyer is entitled on behalf of the client, and the client is entitled to protect. And so there's this pressure. And so part of the job of this task force is to look at these pressures and to actually, we've surveyed 100-odd countries through a lot of bar associations to look at what the international obligations are. And a report will come out sometime this year to identify what we found and to try and isolate some guiding principles to help lawyers in these positions as to the sort of questions they should ask. And, for example, whether they should ask themselves, should I continue in this transaction? Should I continue with the retainer? Even if you don't have a positive obligation, for example, in the United Kingdom, to report something that might be money laundering, that obligation does not exist in Australia, but it does exist in a number of countries, particularly under the EU directives. And so even if you have no obligation, should you continue to act? What is the status of your knowledge? And if you do have some sort of knowledge, are you exposing yourself to personal liability? Because you may well turn a blind eye and be willfully blind to the commission of an offence if you know enough. And so there's some very complex issues that I think lawyers have to think about independently of their relationship and obligations to their clients.
Very, very interesting. We have a question. Do you want to go for... Let's make it interactive. You wanted to ask something.
We can't hear, sorry. We can't hear.
Is there a mic? Yeah. Hey, she's going. Yeah. So feel free to jump in and ask questions. Let's make this interactive.
Okay, number one is the fact that when we talk about money laundering and about transparency, the biggest and the best place to launder money right now on the planet is in the US. I mean, the way you can go ahead and easily and quickly either conceal funds or even launder funds through using trusts, private equity, artwork, or even, real estate, for instance. It's mind-boggling. And the thing is that if we don't have the same standards apply everywhere, one jurisdiction which might claim to be on the forefront of enforcement and transparency is actually going to have an unfair advantage, because guess where do most people hide most of their money today? It's not in the UK, it's not in Europe. Singapore is passé. The best place, if you look at it, is hands down either Delaware, Nevada, Florida, South Dakota, Wyoming, jurisdictions like that. So what's the use of having all these discussions when the fundamental laws that are there to protect privacy are not going to be modified in order to accommodate genuine legal concerns, not only from a law enforcement perspective, but even from a tax compliance perspective?
Let me sort of follow that up to sort of put it to Rob first. Is OECD looking at coming up with some sort of a minimum standards or minimum directives that can be adopted across different geographies to address the issue the gentleman raised, or?
That's a very good point, and one that certainly I know the OECD and FATF, the Financial Action Task Force, has looked at for a long time. And as you rightly say, the biggest resistor to, in effect, disclosure, for example, of beneficial ownership and some form of transparency is not Uzbekistan, is not Russia, is not China, it's the United States. And they themselves are some of the worst, they have some of the worst laws to effectively allow corporations and individuals, be they kleptocrats, be they oligarchs, whoever they are, to launder money and to hide their identity. And so this very issue of trying to identify the countries that are the worst examples of this are limited because they are the ones that have the highest form of influence, if you like, in the task force. And it's not helped by the current administration in the White House, who take the view that what is good for America is good for America and, frankly, bugger the rest of the world. And so, to that extent, it's not going to change, unfortunately. And organisations like the OECD have to be quite careful in terms of expressing their view, because they know that some of their biggest supporters, traditionally in the past, such as the US, frankly have limited interest in changing their laws. And until that happens, the very point you raise is going to continue.
Let's go to Saro. Saro, what's your perspective of how Nigeria deals with legal privilege and the interplay of confidentiality versus duty, any sort of duty to report any kind of suspicious transactions?
I think once you start talking. Right, very interesting. Right now, there's a case going on between the state and the leader of the bar concerning professional fees. The fees that were paid were astronomically high, so there's a suspicion that there's something untoward that happened. And he's claimed that, look, this is subject to professional privilege and is not required to disclose any further information. That is presently in court. Now, but beyond that, there is also the question as to the extent to which you're required to positively disclose when a client actually intends to retain you, and then he discloses some information that perhaps may be criminal. Now, there's a law in Nigeria that requires you to actually act as a police. You're supposed to go back and report that this has happened. But I can tell you that most lawyers, the best you'll get is, decline the instructions. But I don't know of any lawyer who's actually gone to the police to report this. And there's no mechanism to actually verify what happens.
Interesting. One question again, as a follow-up to all of this. Do you also have an obligation to represent a person that comes to you irrespective of the ability to pay? Because that's something that is looked on in India, that you cannot be refusing legal representation on grounds of fees, or you cannot be turning away a client unless you have genuine reasons to do so. You would actually be called by the bar in India for...
So you have to act on a pro bono basis?
If required, so yes, or guide the person to ensure that the person receives legal aid through a clinic or a pro bono. Would that, I'm saying, how would that sort of interplay with your ability to be able to decline on grounds? Because you're already going to be declaring that you believe that a client prima facie has something that you cannot act upon.
The first thing is that in the United Kingdom, there is no requirement to act if you're not going to be paid. So, and one of the shocking statistics of austerity is that the Ministry of Justice budget has halved since 2008.
Wow.
So that means that prisons, legal aid, justice, the prosecution agencies have lost a huge amount of money, which means many, many people are no longer getting public funding. So there are many, many people who do not have representation, and the courts are now, which are underfunded, the courts are now flooded with litigants in person, i.e. people who are representing themselves. In terms of your ability to not act for someone because of the money laundering requirements to provide a suspicious activity report, it's a very interesting question, because you're not allowed to tip them off. And so you would have to, and then we get into some really complex ethical issues, you have to come up, effectively lie to your client about why you don't want to act for them. You'd have to manufacture, which is, again, unethical. So I personally have never been in that situation because of a suspicious activity report, and that's probably because I'm one stage removed as a barrister. One of the lovely things about barristers and why we're such hypocrites is that we say, well, my instructing solicitor will deal with these issues. And so by the time it comes to us, we're very happy that the money has been laundered and we can be effectively paid. So that is something that barristers don't deal with, but it's an issue, certainly. In terms of the privilege issue, so the fee issue in the United Kingdom would not be privileged. So you have legal professional privilege, which would attach to the provision of legal advice. When you're asking for money, you're not saying, I advise you to pay me money. I suppose you could say, I advise you to pay me money, otherwise I won't represent you. But that's not legal advice, so that wouldn't attract legal professional privilege. So it's really the provision of advice, whether that's for litigation or otherwise. And there's some quite interesting issues about when litigation is in contemplation, so, which we could talk about. But yeah, that is a distinction, the fees issue in the UK, definitely.
Yeah. Rob, you have any perspective on this?
Simply to agree with Matthew, the whole nature of the giving of legal advice has got nothing to do with the payment of fees or even the retainer. And there are cases in Australia to say that the agreement between a client and a lawyer as a matter of contract to settle the retainer, agree on fees, is not the provision of legal advice, and therefore is disclosable. What then flows from that in terms of the substantive advice is the giving and the receiving of legal advice, but not the creation of the relationship.
Understood. I think we should move on to another interesting topic which is actually burning in India, is the whole exposure and liability of directors, whether independent or executive, in respect of transactions undertaken by companies and or promoters, and what's the kind of scenario available for them to be able to be able to mitigate their own personal liability versus the liability of the organization. Sorry, go on.
Hi, sorry. So this is an interesting question I was trying to ask myself, because, for instance, in the rest of the world, a company defaults, goes into bankruptcy. If there is fraud, then okay, you can actually go after the malfeasors in civil and criminal venues. But what happens, because in India, even if you are going bankrupt, not because of your own fault, not because of your incompetence, but because all of a sudden the government goes ahead and changes laws and policies and really hammers you in your pocketbook. I'll give you a couple of examples. For instance, GST, RERA, or even demonetization, where people actually had to go begging for their own money, and companies went bankrupt, and people lost jobs, they lost their investments. And guess what? At the end of it, to pile insult upon injury is that you're going ahead and dragging those same directors into court to face criminal and civil proceedings and lose their entire assets, and also go to jail and then wait for bail.
Let's hear from the panel. Osaro, why don't you tell us about director's liability in your job?
Very interesting. As far as banking is concerned, Nigeria took some positive steps. After the troubled assets, the attempt to correct the malpractices in the bank led to the introduction of a particular legislation that causes directors, even though they were not involved directly in the credits or in the failure of the entity, to be responsible by their personal assets. So if a company were to go insolvent and you are a director, the fact that you were not involved in the credits that led to the credit default that led to the company being insolvent, you will be directly responsible only to the extent that you have assets of a particular magnitude. In other words, your asset may be charged, and the burden of proof is then transferred. If you can explain how you came about those assets, then you walk free. Otherwise, those assets will be charged and then distributed amongst.
So I guess they're trying to create an interesting presumption that your assets grew because of your interesting.
Yeah. So that's basically what you have there, and that provision has been very helpful, but it only relates to banks that are distressed or institutions that are distressed.
Understood. Matt, what's your perspective on the manner in which directors are held accountable, and in fact, any steps or mitigating factors that a director can build to sort of ring-fence itself?
Well, this perhaps, talking about steps, and we've mentioned the example of properties being purchased in the United States which are purchased with the proceeds of crime. Foreign directors and those suspected of serious organized crime will now fall underneath the ambit of something called the unexplained wealth orders in the United Kingdom. So in London, they estimate that there are 22,000 properties worth more than £2 million each, which have been bought with the proceeds of crime.
Wow.
And so in January last year, the amendment to the Proceeds of Crime Act came into place. And I'll just read you briefly what the criteria is. If the respondent, so that certain agencies, the National Crime Agency, the SFO, other agencies, have a right to issue a notice if they think someone's bought a property and they don't have any money to buy it, that's obvious to the state authorities, i.e. the tax authority. They've got no financial footprint, and they're buying a house for 26 million. So if the respondent or person is connected to them as either a politically exposed person of a country outside the EEA, so not a European person, politically exposed person means that they have a job within a state entity or a connection to a state entity in the foreign culture, or they are suspected of being involved in serious organised crime. And if that's the case, they have an asset, and this is an interesting test. There are reasonable grounds for suspecting that the known sources of the respondent's lawfully obtained income would be insufficient to enable the respondent to obtain the property. That's the statute. If that happens, then the burden shifts onto the individual to say, and they have to provide a statement. If they don't provide a statement, they go to prison for 2 years. Well, that's up to 2 years. They then have to explain how they bought that property. So these unexplained wealth orders are going to have a massive impact on this issue for serious organised crime and politically exposed people who've bought houses in the UK.
Wasn't there just an instance of a Central Asian, the spouse of a Central Asian leader who lost her home because of that?
Yes.
Let me just add to what has just been said. Quite a number of politically exposed persons will normally purchase property in the UK. So the unexplained wealth order is very interesting to a number of Nigerians. Now, the point you made earlier is very interesting because what happens, most of these politically exposed persons don't live in the UK, so the asset is normally forfeited to the UK government, and then the proceeds of sale is then used in enhancing the prosecutorial agencies in the UK. The proceeds are usually way, way beyond what you need to enhance the prosecutorial agencies, and therefore Nigeria is looking to repatriate those funds, but it's almost impossible. And that's where most foreign countries are unhappy with the way it's working. So it's interesting, you get the funds, yes, we're happy to cooperate with you, but when it's time to repatriate those funds to taxpayers, it's almost impossible.
That's an interesting perspective. Rob, what's your feedback on this issue in terms
well,
of
if you look at directors, under Australian law, a director is a director. It matters not whether the director is executive or independent.
Oh, really?
They are and remain liable for whatever they are liable for as a director. Picking up the question that was raised there, if the collapse or insolvency, for example, of a company is unrelated to the conduct of the directors or management, it happens because of external circumstances, then there may well simply be no liability on the directors because it's not their fault that a company failed or lost money. If, however, the failure, the loss, the fraud, whatever it is of a company is caused or contributed to by decisions made or the conduct of directors, independent or otherwise, then they can be held accountable in any number of ways by breach of their statutory director duties, which apply to all directors, irrespective of their independence or not, or under the insolvency provisions, which allows a liquidator to effectively come in, examine the affairs of the company, interrogate directors and officers under statutory examinations in court to find out what happened, assuming there are funds to do that or funded by creditors or a third party, and then to potentially make claims against directors on behalf of the liquidated entity to essentially get money back in for distribution to the creditors of the company. So it's a misnomer to say you're independent, therefore you're not liable. It's just nonsense under Australian law. And we've had federal court authorities that have said to directors, if you don't know Finance 101, if you don't know your business, go out and learn it. Understand what Finance 101 means so you can read financial statements. And there was a famous case called Centro where the directors ran a defence that they didn't know and didn't have to know the detail of the financial operations of the company because that was management's responsibility. The federal court said nonsense. 101 finance is your obligation. Go and understand it, go and learn it, and apply it as a director because that is your duty, independent or otherwise. So it's pretty severe, and that's why people now are starting in Australia to think twice in any number of sectors about what you need to be and what you need to know as a director. And by the way, make sure your D&O insurance cover is up to date.
Interesting. I think there's another topic that we can bring a perspective before throwing the floor open to the audience for questions, is how in each of your respective geographies are regulators looking at money laundering issues? Are they really going after organizations? Are they going after individuals? Are they trying to prosecute in terms of disgorgement? Is disgorgement kind of the primary objective? That is the underlying theme for these investigations. Is it punishment and penalty, imprisonment? Is that sort of the underlying theme? How is each of your geographies looking at AML? Matthew, you want to go first?
I think a lot of it has got to do with chance, if I'm honest, because there is so much fraud and money laundering in the United Kingdom. So they estimated, I think it was last year, that there was 98 billion pounds generated from fraud in the City of London.
Oh.
98 billion. And so they just don't have the resources to investigate all that fraud. And so they have something called the Action Fraud Helpline. So if you're the victim of crime or fraud, an old person who's been missold pension that doesn't exist, or a property in Madeira that doesn't exist, whatever, these sorts of scams, you ring up this line, you have a less than 2% chance that your complaint will even be investigated because this is the budget cuts. And financial crime, the resources of the average police force, they do not have financial experts to deal with that. So when I say it comes down to chance, a lot of it's going to be, if there's a media spotlight, then the SFO might focus on something, and then that company might get chased. For example, Rolls-Royce.
Yeah, interesting. Rob, you want to quickly give us your perspective in terms of what are the regulators really chasing? Are they chasing people? Are they chasing the money?
In short, not a lot. And what they do chase tends to be old-fashioned black crime, murder, rapists, people like that. Whereas financial crime, too hard, too difficult, and is generally of very small quantity, as Matthew said, simply because of resourcing, skills, and in Australia, a lack of a dedicated agency. So there's no one authority that is responsible. There's a whole range of different authorities that look after different things, and that's a real problem in itself.
Usaro, a quick perspective from your side?
I think what Matthew said is actually correct. There is complexity in pursuing financial crimes. The judicial system is not as efficient as we would like. What the Minister of Finance did a couple of years ago was to introduce a whistleblowing scheme where part of the funds that were recovered were shared with the whistleblower. That really helped. And then there was also some sort of introduction of a plea bargain. The statute does not allow a plea bargain, so there was that philosophical argument as to how you're going to do this. But that was the only way they could deal with some of the issues, just a tiny little bit, because of the complexity, of course, of pursuing financial crime in the absence of the expertise. So we're facing that problem, but I think the whistleblowing scheme has worked effectively. Recently, because of politics, it was slowed down. Now that the politics is over, and I think we now have a president who is determined to fight corruption, we're going to see a lot more prosecution, and I think they will revive the whistleblowing scheme.
I think for me, at least, it was encouraging to know that we are not the only ones who are struggling on an institutional basis to be able to deal with sophisticated financial crime. I think rather than opening up the session for questions, we can all maybe interact with each other at lunch, because I believe there is lunch which is awaiting all of us and the rest of the sessions to follow. Thank you very much for being such a nice and wonderful audience.